So we've got our third and last of today, which comes from Agent Chu. And the question is dealing with a leak in a complex that they had, which was in the apartment, right? So it goes as follows. We got a leak detection to find the leak in this apartment as it was coming through the cupboards. However, they confirmed that the leak was from one of the other units on which was behind their apartment. So the leak detection was now done again in the unit behind them, and definitely for sure they found the leak in the shower wall. The body corporate then is saying the owner of the unit where the leak was found is liable for all the leak detection that was done in the complex, and he has to repair and retile the leak and the shower, right? It also is now being said that the body corporate that has made liable for any damages caused in the other unit from the water that was pushing through, and that the body corporate insurance won't cover any of this, and it's going to make that specific tenant responsible for all damages caused. So their question and bottom line is that they just want to know that, or to make sure that, is this normal that the tenant becomes liable for all the damage that was caused in the complex and in other units by the specific leak happening in their own apartment? Gentlemen?
Sure. Sorry, so from my side, if I understand the question correctly, there's two owners living next to each other. Each of them has a unit. The one owner's unit is getting leaks in, and they did a bit of research, they did a bit of an investigation, and they found out that the leak is coming from the unit next door, right? So we want to find out whether the aggrieved owner, so the suffering owner, as it were, we want to find out what he can do. So is it a question of, listen, body corporate pays for insurance, come cover me? Or is it a question of, listen, sue the neighbor because the neighbor's done something that it's not part of the body corporate's responsibility? Am I right? Is that the answer that we're looking for?
Yeah, that's how I interpret it as well.
Yeah, it seems as if the body corporate has actually made the tenant who the leak came from liable for all the damages caused in his own property and the neighbor's property. So now they just want to know, is this normal that that specific tenant becomes responsible to pay for the damages?
Okay, so the only reason for this clarification for the viewer's sake is using the word, so when we say tenant, in situations like this, whether it's a tenant, whether it's an owner, so the person that actually owns the unit, in cases like this, especially when it's a defect in the unit itself, it usually falls within the responsibility of the owner, as opposed to, for example, it being an individual's fault and suing the individual because they specifically did something wrong. So my understanding here, or the answer I would give off the cuff, without legal advice being sought, which I'd strongly suggest that one first look at the insurance policies and look at the body corporate rules and things like that, and obviously look at the structure. Because we've answered this a couple of times, and these are always difficult questions, because body corporates have obviously things, common property, so certain sections that fall within the body corporate's responsibility to maintain. So things, for example, where you look at units that are above each other, certain spaces between the two units, as an example, or spaces between the roof and the ceiling and the unit itself. Who's supposed to take responsibility for that? And often the design of the body corporates would dictate whether this is common property that everyone needs to share, elevator shafts, that sort of thing, or whether it's, it's basically half the wall belongs to one owner, half the wall belongs to the other owner, right? As you would with normal freestanding. So off the cuff, I would say, without you really considering any of those dynamics any further, if it's two neighbors touching walls, the reality is that the walls should have been waterproofed, right? And the design of the construction of this specifically sectional title, one would expect this to happen. So I'm already now on the fence when it comes to this, because blaming the owner who, for example, has a shower there, did the owner install a shower there without it being allowed? Who actually did this build? whose responsibility is it? Like, you bought it from a developer who established the body corporate. So now it's a defect that's sitting there, and it's a construction defect as opposed to a defect that you caused. So questions like that are very important, because yes, it might very well be that owner's responsibility to ensure that his unit doesn't infringe on the rights of the other person. But does that owner have no recourse at all, or can that owner then go forth and actually claim from a developer to say, well, the way that you constructed the property, you didn't do proper dam proofing, you didn't do this, you didn't do that, you have to repair it, or you have to compensate me for the damages now suffered due to your negligence. So you see, unfortunately, you've got this line here on, you bought the property, it has a defect, it's now caused damage, it's not your fault, but what do? You now have to go get recourse against the guy that sold you the property. So off that information, that's probably the best answer I can give. Nick, I don't know if you want to add anything to that.
No, I think you're exactly right. Questions like this are very complex, and at first glance, you want to sit there and go, okay, well, the one owner's shower is defective and that has caused the damage. So that is, that would flow from the fault there. But you're absolutely right. I mean, you need more information about why this shower is damaged. Is it a build problem? Is it a damp proofing problem? What is the cause? If it's as simple as, like you say, the owner that built the shower did, some work on the shower and has caused a damage, and that resulted in the leak, then yeah, sure. The way the body corporate has dealt with this, you're the owner of the shower, it has caused the damage, you're liable, then yes, I would agree with the position. But it's simply not that simple when it comes to properties, when it comes to, especially walls that are touching various units in a scheme. There's some additional questions that have to be asked to find out where actual liability lies. So I'm with you. There are some other questions that need to be asked in the circumstances, and some real research that needs to go into this.
Yeah. So thank you, gentlemen. Obviously, as you state, there has to be a proper investigation that needs to be done. It cannot be a case of just quickly blaming the one tenant or the owner or the landlord or the body corporate. One is to look at, maybe, is this a common property section that it's falling under, right? Are the walls even waterproofed at this point, or is there even a construction defect where possibly one can claim from the developer in the case of perhaps that type of negligence? So thank you very much for touching on all those points, and I think that brings us definitely to the end of today's episodes. Thank you very much, everybody, and we'll see you again next week with some more questions and answers.
Cool. Thanks, guys.
Thanks, guys.
Thanks. Yeah.